Hello everyone, welcome to lesson 2 for tort law. In lesson 2 we're going to be looking at psychiatric injury. Once again, if you find this video useful, please like and subscribe, and we're going to move forward now looking at a bit of the background. So negligence and personal injury. Just to remind ourselves that negligence in terms of tort law usually results in personal injury being suffered or property damage. Now, the history briefly to psychiatric injury is that the courts were initially unwilling to accept psychiatric injury because, of course, there's no sort of physical damage there. Or, to term it another way, nervous shock. Really, it was only until medical advancements that the law grew to understand that psychiatric injury was possible, and therefore the victim should be compensated. So I think initially we're just going to see how the law has developed and how the courts have slowly but surely allowed claims to be successful. So the starting point, and the most obvious, is that the claimant must suffer psychiatric harm or mental injury. Now, this has to be supported by medical evidence, and it has to be, as I said, a recognised psychiatric disorder. So, of course, what sort of examples might they be? You've got, of course, depression, anxiety, PTSD or post-traumatic stress disorder, nervous shock, which is really sort of as well an umbrella term, pathological grief, and adjustment disorder. So it's not an exhaustive list, but here are just some of the things that have ultimately been successful with claims. Now, the case of Vernon and Bosley, the claimant witnessed her children being rescued from a fire. Why did her claim for psychiatric injury fail? And quite clearly at this point, the courts were not willing for a claim to succeed if it were where the claimant has simply suffered shock or grief or sort of mere emotion. So the Court of Appeal made quite clear there it has to be something that is more permanent. Now, I like to show my students this case study, just really showing how the thinking lies behind such claims. So the Ariana Grande concert that took place in 2017 in Manchester Arena, was reported, of course, that there was a suicide bomber, a terrorist, and unfortunately when he detonated his bomb inside the arena, thousands of young people and parents were there, having attended the concert to see Ariana. 22 people killed, 500 were injured, and you can see there from the sort of diagram here sort of the layout of the arena itself in Manchester. So the blast area there was just, as I think you can see there, on one of the exits from the arena, but still within the sort of building. And you can also see there's some stairs there from the blast area. So they've, in the videos that ultimately came out, recorded on mobile phones afterwards, people were seen running down these stairs in the video. Now, one account, just to put this into perspective, of one of the victims, a person was there with friends and her daughter. She was making her way through the foyer when the explosion happened. Now, she suffered a superficial head injury, was covered in blood and body tissue from others. Now, she made her way back to the stage area where, of course, the detonation had been, and saw that many were seriously injured, and as a consequence was traumatized and suffered psychiatric injury. Symptoms of that psychiatric injury included being overly protective of her daughter, as one can understand, a fear of entering Manchester and busy places, vivid recollections, flashbacks, severe anxiety, panic attacks, and fear for her own safety. So this psychiatric injury, which is clearly more than mere emotion and it is permanent, has incapacitated her to a great extent and impacted her life in terms of not just pain and suffering, but loss of amenity as well, and loss of lifestyle and things that she would like to have normally been able to do. So that's the sort of claim that we could be dealing with in terms of psychiatric injury in tort law. Now, the position that the law takes is that there are two categories of claimant, potentially. The first is a primary victim, and we can define a primary victim as a person who is present at the scene and therefore, at risk, to put it another way, within that zone of danger. That proximity test is met. So they're at risk of foreseeable injury, or they're present at the scene and suffer some injury. So a question might be, if we're relating it to a news story, an event that happened not so long ago. We talk about the Grenfell Tower fire, where I think it was due to a faulty kitchen appliance, that a fire took hold, and of course the cladding on the outside of the building was the wrong material. It shouldn't have been outside of that building, and in fact was highly combustible and spread the fire through the building far more quickly, killing many people. Now, if a firefighter at that fire suffered psychiatric injury, should they be able to claim damages as a primary victim? So I think, in terms of, first of all, fairness, the courts are prepared to acknowledge that a rescuer, for example, professional rescuer as a firefighter is, would be considered primary victim, because of course they are placing themselves at the scene in the zone of danger, so entering that building while the fire in that instance is still raging, and putting their own lives at risk to save others. But even notwithstanding professional rescuers, some, for example, a citizen, a member of the public who witnesses an accident and then tries to perhaps pull someone from rubble or such, if there's been an explosion or a building's collapsed, again could claim as a primary victim. So the case we have here is Chadwick and British Railways Board, and the case facts briefly. That's from what I could find, an actual picture of the scene. The claimant witnessed a train crash in which 90 died and many were severely injured. Living nearby, he spent the night crawling in the wreckage to aid trapped victims, and of course consequentially suffered psychiatric injury and was able to bring a successful claim. Now, of course, that was 1967. If we just look at the following case of Delu and White, which is earlier, 1901, I think you can see how the courts were very reluctant to want to allow successful claims in all instances. So the case facts of Delu and White: the claimant here was pregnant, working behind a pub bar, when a horse and cart crashed into the pub and narrowly missing her. So of course that makes her a near misser. She suffered psychiatric injury and brought a successful claim. So far we can see that it's only if you are, the courts were willing to allow a claim if you were directly affected. And now, of course, we term that primary victim. So if you are somebody that was at risk, either at the scene, as you can see in Delu and White there, literally as the accident is happening, or indeed as a rescuer, perhaps just at the scene, obviously, as well, then the courts are willing to allow successful claims for compensation. However, where the courts were reluctant to develop further, and it took a great deal of time, as I said, and medical advancement, is those we might term secondary victims. Secondary victims are quite the opposite of primary, in that they were not involved in the accident itself, but typically they've witnessed it, and they've suffered psychiatric injury. So they've either, as I say, witnessed the scene or its immediate aftermath and have suffered psychiatric injury. So let's look at some of the issues then that befalls a secondary victim, because of course, let's just look at this example. If someone were to watch a video or see images of a negligent accident online, perhaps somebody had recorded it on their mobile phone and put it up on social media or YouTube or whatever, and consequently having watched this, you suffer psychiatric injury, should you be able to claim damages? It really, I think, the key case to focus on for secondary victims, and where perhaps some of the restrictions and limitations have been put in place by the courts, is the tragedy that happened at Hillsborough Football Club Stadium involving Liverpool and Nottingham Forest back in 1989. So this, highly, high-profile football match was being televised, and unfortunately, what there happened was crowd control wasn't properly dealt with. Large portion of the crowd were moved, the way that the police were marshalling them as well, and of course back then you had where the fans were seated, fences, like perimeter around the pitch to stop them from, I suppose, any potential fans from invading the pitch. And of course, as the fans were moved and there were too many fans there and the police were marching them forward and so forth, it caused panic, it caused a large crush, a fatal crush, killing 95 people and actually injuring over 400. And whilst this was happening, and it was all being televised live on television, and of course also broadcast on the radio, this football match, family members and loved ones were claiming, of course, that they were watching, if they were watching the television, their friends and relatives die in front of them, knowing perhaps either if they spotted their face, or maybe they knew they were somewhere situated in that part of the stadium. Certainly they knew they were there and there were people dying. While of course others still who were present in the stadium heard about the events that were happening in part of that stadium, and subsequently suffered psychiatric injury. So what are the arguments for and against claimants succeeding with their claim for psychiatric injury against the police? And of course it took many years, but eventually, in only the last few years in fact, the courts did find South Yorkshire police were negligent in how they handled the situation, and of course the senior officers who were responsible on the day. So the main issue that faced the courts were, if they were to allow potentially everyone in the stadium to claim, provided of course there was recognised psychiatric injury, and anyone watching the match on television, and of course anyone listening to it perhaps on the radio as well, then you have an audience of immeasurable size. You would have a lot of claimants, and I think this worried the courts, firstly in terms of the amount of time that might take, and how sort of too open and broad it could be for people coming forward. So it was fearing that the floodgates would open to too many claims. They wanted to prioritise those who are most deserving. This is a public policy reason, but we can also criticise this public policy reason, because whilst it seemingly focuses on those who are most deserving, those for example within the stadium who were I was going to say, if they're at risk themselves, they would claim as primary victims, but those in the stadium who would subsequently then need to pass additional tests we're about to talk about, but they could potentially make a claim if they witnessed something or the immediate aftermath and suffered psychiatric injury. But even still, the courts weren't just going to allow that claim to succeed like a primary victim's claim would. If you're a secondary victim who witnesses it, but you're not at risk yourselves, then this case, the Hillsborough case, which we're going to refer to in a minute as Alcock, developed some further tests that a successful claimant will have to bring. And all of this is to prevent the floodgates of claims being brought forward. Now, as I said, you can criticise this because if you don't meet the Alcock tests to become a successful secondary victim, then you are somebody that is left, potentially with psychiatric injury with no compensation or avenue legally to remedy that. So, you could have watched that on the television. You could very well have suffered a recognised psychiatric injury, but the courts weren't willing to automatically allow that claim again because of the floodgates argument. So you can see some sort of criticism there. So the case with Hillsborough, as I referred to, is Alcock, or more fully, Alcock and Chief Constable of South Yorkshire, and this was the House of Lords, our most senior court, of course more recently replaced by the UK Supreme Court. And they said, we need to differentiate between primary and secondary victims. So these 4 tests that came about, known as the Alcock tests, are as follows. The claimant must have close ties of love and affection with the victim. Now, what that would seem to suggest is that there is a presumption there, if it's a parent to a child or a partner to their spouse. Anything sort of outside of that, certainly would need evidence to support it. Secondly, the claimant suffered mental injuries at the scene or in its immediate aftermath. That's the proximity test that I spoke of, and that one is something that, particularly in exam problem scenarios, the examiners usually asking you to discuss. So we'll come back to that in a moment. Thirdly, that the claimant suffered shock through their own unaided senses, and this goes back to the point in Alcock where I said the courts, House of Lords, were not willing to allow claims by those who had watched it on television or heard the match and the terrible happenings through the radio. So you have got to have seen it or heard it yourself, as opposed through the medium of a broadcast. And the last part here is a sort of threshold test, again just making sure that the claim is not too easily made, that a person of reasonable fortitude would have suffered mental injury. So it's a question for the court, and of course one would say if somebody witnessed the death of a loved one, say their wife, due to somebody's negligence, and they suffer recognised psychiatric injury, then I think certainly it's reasonable to say that somebody of reasonable fortitude, reasonable strength, reasonable sort of mental sort of composure would be affected. If it were a stranger that had died, it would fail the first test, and of course you wouldn't have that same level of impact of that person's death upon you, perhaps, as you would somebody who you deeply care for. So that's kind of the thinking here with the tests. And also, I think just one more point, I've got this, as I said, on the next slide about immediate. The longer the time that passes, the less likely that your psychiatric injury, if you're claiming for, was caused by this traumatic event. So it's really a case of the clock is ticking on what is acceptable for a claim. So let's go into that now. You've got firstly case of McLaughlin and O'Brien, and the ratio here is that term immediate, if you're claiming as a secondary victim, is that the immediate aftermath of witnessing a traumatic event has been stretched by the courts up to 2 hours. If it exceeds 2 hours, you fail that second part of the Alcock tests, and therefore you can't claim, it would seem, as a secondary victim. So here, the claimant's husband and children were involved in a road traffic accident. She arrived at the hospital and she saw her family suffering before they had been treated, so that was kind of like the immediate aftermath. She suffered recognised psychiatric injury, and as I said, the House of Lords were accepting of her claim here and setting precedent that arriving at the hospital, witnessing her family before they'd been treated, was the immediate aftermath, and all within that span of sort of 2 hours since the horrifying event. In terms of North Glamorgan NHS Trust and Walters, just note here this is a 2002 case. You can see, probably again out of principle of fairness, because as I said before, if you don't meet the test for immediate aftermath as a secondary victim, then you will fail as a secondary victim in your claim. You won't be a secondary victim, but you will still be left with a psychiatric injury and no compensation. So I think in 2002 with this case, the courts are recognising that that time that immediate aftermath sort of equates to perhaps needs to be extended, just to allow claims that would otherwise not be successful out of fairness, really, and sort of justice. So if we have a look here, the claimant's infant son died in her arms when the hospital negligently failed to diagnose her son's acute hepatitis, resulting in seizures and brain damage. And unfortunately, the mother witnessed a number of seizures that her infant son suffered until he eventually died. And all of this is, in terms of the court's interpretation, not just one traumatic event that she's witnessing, the mother, but a series of traumatic events. And if indeed there is a series of traumatic events, then the courts are willing to extend the time for what is considered immediate aftermath, and they have here up to 36 hours. So in terms of an exam question, look for whether or not it's one traumatic event, as it typically tends to be. For a secondary victim claim that's successful, it would have to be suffering that mental injury within the immediate aftermath of up to 2 hours. But if it's a series of events, typically things like somebody going to the hospital quite soon after the event, witnessing things as this, for example, mother did, then it's up to 36 hours. But anything beyond 36 hours would seem to make the claim fail. So in North Glamorgan NHS Trust case, the Court of Appeal accepted her claim. The Sion and Hampstead Health Authority case said that the ratio here is nervous shock. Again, that's a recognised psychiatric injury. Must be from a sudden, horrifying event. And I think this is just trying to make the point here that it is that sudden event that is causally linked to the psychiatric injury that you suffer. So if we look at the case facts here, the claimant's son was seriously injured in a motorcycle accident. At the hospital, they failed to diagnose a bleed from his kidney, and the person fell into a coma for 3 days and suffered a heart attack. He was placed in intensive care but died subsequently 14 days later, with the claimant remaining with their son throughout, and obviously just before the death. And the claimant suffered psychiatric injury as his son deteriorated. So of course the courts are making very clear here that it has to be a sudden, horrifying event for a claim to succeed. And just to really recap in terms of analysis and evaluation, assessment objective 3, which as you recall is as an objective is present for AQA in all problem scenarios. The 10 mark problem scenario at the very least, up to the 30 marks question. But of course things like this are typically useful for the 15 marks question, which often gets us to look at what we've studied and in terms of be it fault or justice or whatever. And so here we're just saying that it is fair, the Alcock test for secondary victims, prevents too many claims reaching the court, focuses on the most deserving, if you were going to look at it that way. In terms of certainly those with close ties of love and affection will be affected more by witnessing the death of someone close to them. And of course it does save time and money for the courts. Unfair, as I've said before, it does have that issue where it leaves people who have suffered psychiatric injury, no legal action, no compensation, their lives, detrimentally impacted. They're more or less left to get on with it. It's also worth noting that bystanders cannot claim at all, unless, of course, they can satisfy the 4 tests we discussed for the Alcock case criteria. And if they do pass that, they can successfully claim as a secondary victim. But if they can't, then that bystander, as I said before, who may witness a complete stranger being, for example, seriously injured or killed due to someone's negligence, if they suffer psychiatric injury, they have no claim, because, as I just said, they will not be able to pass the close ties of love and affection part. So we've got here, Rana witnesses a runaway lorry going downhill towards where she had left her children. She then hears from a nearby bystander that a child was involved in an accident. Rana suffers nervous shock. Will Rana be successful with her claim? Of course, if you want to pause the video and have a go yourself, I'm going to talk through the answers to these. And what we're asking ourselves, first of all, like we would in the exam, is there a successful claim for psychiatric injury? So we're looking for a recognised psychiatric injury first, and then we look to what category of victim might they be. So here with Rana, she says at the bottom she suffers nervous shock. That is a recognised medical condition. Vernon and Bosley case, quite clear that would be fine with medical evidence supporting such a claim. Is Rana a primary victim? Is she somebody that is at the scene, at risk, in that zone of danger and suffers psychiatric injury? Where it says there she witnesses a runaway lorry. So it's quite clear here she's not in any danger herself. So she would, in all intents and purposes, be a bystander as she's witnessed this runaway lorry, unless, of course, she can successfully pass the Alcock criteria as a secondary victim. Now, if we look through here, firstly, we're dealing with close ties of love and affection, and Rana believes that a child was involved in an accident. Now, she had left her children within the vicinity of where this lorry was meant to have gone. So I suppose in this context, she doesn't know if her own children may have been seriously injured or killed. So I think, close ties of love and affection is the first test. And I would say here, a parent and a child or children, there's a presumption, there's a starting point that will succeed for evidence of close ties of love and affection. The second point you recall from Alcock is, was their mental injury suffered at the scene or in the immediate aftermath? Now we know she suffered nervous shock at the scene. Let's see, witnesses a runaway lorry go downhill. She then hears from the. You could argue it's sort of at the scene. She's a little bit more removed from it, but we know she's not in any danger herself. This is why she's trying to succeed as a secondary. So suffered mental injury, and you could say more or less at the scene, if not the immediate aftermath, if you want to argue that. I think where the problem where this one lies is that the third test for Alcock says that it should be her mental injury and so forth suffered through her own unaided senses, and of course she doesn't. She hears from a nearby bystander, so she doesn't see the accident for herself nor hear about it herself. She's hearing it through a third party. And similarly, as I mentioned in the Alcock case with the Hillsborough tragedy, those who witnessed it on television or heard it on the radio and such, the courts weren't prepared to extend a successful claim for secondary victims to them. So this means that Rana is not going to be successful in her claim, even though she's left with psychiatric injury. And of course the last test would have been, would a person of reasonable fortitude have essentially suffered the sort of same injury? And I think, the court would probably say yes, particularly given the context of it's a mother and her fearing for her children. But because not all four of the tests pass, then Rana is not going to be successful. Then we've got Doug, works on a building site as a crane operator. The rope supplied by the company was too weak and snaps, causing a crate to fall. He frantically climbs down and sees another worker, Paul, who is recovering after narrowly being missed. Soon after, Doug suffers from acute anxiety and cannot return to work. Will Doug's claim succeed? So, first thing to look at again is there a recognised psychiatric injury? Well, we can see here Doug suffers from acute anxiety, so that is, acceptable with medical evidence. Do we categorise Doug as a primary or secondary victim? Well, Doug, it would appear, whilst he may be at the scene, he doesn't seem to be at risk himself, so that would preclude him from being a primary victim because he's up in the crane. It's obviously those who are below that are at risk. So he could be deemed simply as a bystander. Again, less, of course, he can claim as a secondary victim. And once more, the Alcock criteria will have to be applied. Are there close ties of love and affection between Doug and his co-worker here? And you know what, looking at this, I don't think that test is going to pass. There can't be a presumption like we've dealt with before. This is not a parent-child, or sort of partner-spouse situation. It's just another workmate. And of course, we don't really know, if at all, how close they are. Whether evidence could suggest otherwise, but I would think this claim would fail on that basis. But to talk through the other parts of the test anyway, mental injury suffered at the scene or immediate aftermath, I think you could say at the scene, through unaided senses, appears that Doug has, he sees Paul, who is recovering after narrowly being missed. So I guess you could say unaided senses in the immediate aftermath. So it's immediate aftermath, that we're dealing with here. And of course, unaided senses, well, he sees Paul, so that would be met. Threshold test, I'm not so sure the threshold test would pass either. So I think here the claim as a secondary victim fails for Doug, because there are no close ties of love and affection seemingly, and the threshold test fails. Now, I can't recall what I put before. I put the word possibly. I do think this fails, in all honesty. Ravney, a fireman helping out at the scene of a building that is on fire, rescues some of its occupants, but is not able to save everyone. He suffers post-traumatic stress disorder as a result. Will Ravney's claim succeed? So once again, we need a recognised medical condition, a psychiatric condition. We have post-traumatic stress disorder, so that's sufficient with medical evidence. Do we place Ravney as a primary victim or a secondary victim? You can see quite clearly, I'm sure, that we're dealing with someone who's a rescuer here. So we're looking at somebody who is, at the scene and at risk themselves. And of course, that case we dealt with, Chadwick and the British Railways Board case, where somebody actually, after a train crash, involved themselves to try and help people. This claim looks like, on the basis of it being primary, that it would succeed. There might even be an argument, they were not given too much in the scenario, that could we also consider Ravney a near misser? The building's still on fire. But certainly I think rescuer, so primary victim, it will succeed. He is in the zone of danger, at risk. We've got Alvita watches her son, so these are three new ones. Alvita watches her son deteriorate in hospital over a period of months until his death. His death is the result of complications and poor treatment by the hospital. Alvita suffers psychiatric injury during this time. Will Alvita's claim succeed? So again, recognise psychiatric injury. Let's see. It just says she suffers psychiatric injury during this time. So face value, and with medical evidence, that looks like that will be fine. according to the Vernon and Bosley case. Do we place her as a primary or secondary? She watches her son deteriorate in hospital, so she's not at risk herself, so we put her into the secondary victim bracket potentially, but she's going to have to pass again those Alcock 4 tests. So do we have close ties of love and affection firstly here? Well, it's Alvita is, watching her son, so mother and son. Presumption here, the court will accept there is a close ties of love and affection. Secondly, was there mental injury suffered at the time, or at the scene, or its immediate aftermath? Now, we're dealing quite clearly here in the hospital, an immediate, perhaps aftermath situation. We know from the case law that the courts are very reluctant to extend this for a long period. So we've got, for one traumatic, horrifying event or sudden event, up to 2 hours, and for a series of traumatic events, we learned earlier, didn't we, that it could be up to 36 hours. So we've got McLaughlin and O'Brien case for up to 2 hours, and we've got the Glamorgan NHS Trust for the up to 36 with a series. But for Alvita here in the scenario, it says a period of months, and so for that reason it does appear that her claim is not going to succeed as a secondary victim. To finish the remaining tests, is it through her own unaided senses? Well, yes. She is witnessing her son's deterioration and death, so she sees it and she hears it. And the threshold test, would a person of reasonable fortitude suffer the same in such circumstances? And I think the answer would be yes, but the claim will fail as a secondary victim on the basis of its months, not up to 36 hours. I've also put there, actually, also the psychiatric injury has not come from a sudden, horrifying event. That was the Scion case. So I suppose you could see here that she watches him deteriorate, but there's an argument there perhaps that there's not a sudden horrifying event, but I think it's largely the time issue. Jing is watching a Formula 1 race on the television when she witnesses a steward get hit by a car. Jing does not know if he is dead. Beg your pardon, I've just changed the gender of the person, haven't I? It says Jing is a she, and I've made it he, so we'll stick to she. Jing is watching a Formula 1 race on the television when she witnesses a steward get hit by a car. Jing does not know if... see what I've done here. It's the steward that's a he, right. Jing does not know if the steward is dead and suffers nervous shock as she watches the report at the scene. Right, okay. So, in relation to this, do we have a recognised psychiatric injury? Yes, we do. We have nervous shock. Support that with medical evidence, Vernon and Bosley. Do we place Jing as primary or secondary? Well, she's clearly not primary. She's not at any risk, not at the scene herself. So she would have to try and claim as a secondary, and that means the Alcock case criteria. And very quickly, if you're recalling the criteria, it's going to fail for a couple of reasons. The first, we have close ties of love and affection, clearly not there. Secondly, and I think the main issue here as well, is that she has not witnessed this, Jing, the steward being hit by the car, through her own unaided senses. She's watched it on television. So quite similar to the precedent laid out in the case of Alcock and the criteria we're discussing, where the football tragedy at the stadium, people were watching this unfold on television or listening to it on the radio. Jing is watching this on the television and through, basically not through her own unaided senses. So the claim will fail as a secondary. Rona is walking in a high street when a runaway truck, the driver, has heart problems, did not tell his employer, and he suffered a heart attack, ploughs into pedestrians. Rona dives out of the way to avoid it, but subsequently suffers PTSD. So PTSD is recognised psychiatric injury. Do we place Rona as a primary or secondary? Well, I think the key bit here is Rona dives out of the way. So she's clearly at the scene, but she's a near misser. She's a near misser. She was at risk herself. and for that reason her claim will succeed. And of course it was the case of Delu and White, where you had, if you recall from what we discussed earlier, the pregnant woman in a pub when the Horton cars crashed through and narrowly, misses her, the claimant, from suffering serious injury or death. So near misses would succeed as primary victims. Finally, we've got here, I think, in the news 2018, a story that, again, perhaps a more modern one or more recent one, illustrates this topic. You can see the link there from the Metro on the left, but here we have policewoman Cara Creeby, so the pictured there to the right with her partner. She was suing the Metropolitan Police for £200,000 in damages after having to watch 100 child rape videos. Now, of course, this was part of her job as being part of the child abuse sort of, unit, and she would have to look through some horrible footage in an effort to try and, catch the perpetrators, to gather evidence. But I think the issue here is she was having to watch some horrific content. She did actually raise this issue with her employer at the Met, and of course employer has a duty of care towards you and your well-being, and she was essentially told, well, there's no one else to do it, you're going to have to do it. And so even though she was saying she was being affected by this, there was no support forthcoming from the Met Police, and ultimately it led to her suffering psychiatric injury. So there's an example of a claim. And we've reached the end of this video. I hope you found it useful, and please do check out the other tort law videos in my series. Good luck with your revision.